Good morning. Good afternoon, Dave. How you doing?
Good. Yourself?
I'm doing well. Welcome everyone to the Employer Handbook Zoom office hour. My name is Eric Meyer. I am the publisher of this blog called the Employer Handbook. I assume most of you, that's why you're here today. But some of you are probably friends of my guest, Dave Miklas. Dave, why don't you tell everyone a little bit about yourself?
I'm a labor and employment attorney. Been doing this for 22 years. I actually do labor law also, not just employment law. I just don't enjoy it as much involving the unions. But everything in the last year pretty much has been straight up employment law. But things will change with a lot of union campaigns going on under President Biden. We'll see.
Yeah. I anticipate we'll get some of that too. And before I forget, folks, I'm going to put all of our contact stuff in the chat window down below.
Thanks.
I got it all right. If you guys have questions throughout the session, please post them in the chat. If you have comments, post them in the chat. If you have tech issues, I don't want to hear about it. Nothing I can do. But here's the other thing. Dave's a lawyer. I'm a lawyer. Some of you may be our clients, but for purposes of the next hour, you're not really our clients because we're not giving any specific legal advice here. This is a free Zoom, folks. We get paid to do what we do, all right? So no legal advice here. We're not creating any attorney-client privilege. We assume that every question you ask is hypothetical, and you're asking for a friend, right? And don't ask anything specific to New York City because neither of us are licensed to practice there, or California for that, right?
Neither of those countries.
But if you have questions, please do post them in the chat. Things we're probably not going to address today. Sorry to burst your bubble. Tops on that list is COBRA. Neither of us are employee benefits attorneys. However, if you guys want it, I will have another Zoom. I'll bring in one of my employee benefits partners and we can talk about COBRA under the American Rescue Plan all you want. So if that's something that would interest you, post that in the chat and I'll make sure to line something up for a future Zoom. But otherwise, this is probably going to be very FFCRA and OSHA heavy. Dave, why don't I share my screen? Because not only did we both dress up, I mean, Dave told me he's going to wear a suit. So I figured I got to wear a suit. If he's going to wear a suit, I'm going to wear a suit. Dave also brought slides with him. So this is really highfalutin today. We're doing this. We're doing this real deal. Let me bring up Dave's slides. Let me do this from the beginning. Dave, you want to talk a little FFCRA?
Yeah, sure. So I think everyone hopefully is aware of what the requirements were. The mandate ended on December 31st, but one of Trump's last things in office was to extend for those who wanted to voluntarily extend paid leave benefits through the end of March. They were allowed to extend them. That didn't mean any new buckets, but under the American Rescue Plan, it does. So in general, from April 1st through December 31st, you all should have had a poster up in your workplace. It doesn't really need to be up anymore. It's not really applicable, but there's a couple boxes in there that we might want to talk about. But in general, the FFCRA has two prongs to it. One is emergency paid sick leave, which Eric and I will probably refer to as EPSL. And then also the expanded family medical leave. And that does apply or did apply to employers, even if you weren't normally covered under the FMLA, if you didn't have 50 employees. So a lot of small businesses started to have to give paid leave for certain COVID-related reasons. Now, the big news under the American Rescue Plan is that employers that want to voluntarily extend those benefits to their employees will get a tax credit. And the big news is that they've expanded what the reasons are. So in addition to those 5, even though the box says 6, there really were only 5 reasons for the paid leave under the FFCRA. Now we have a whole new reason, and this one is what's on the screen. It involves if your employees are getting tested for COVID or have complications due to getting a immunization. So that's the big news moving forward, which will probably impact a lot of workplaces. What do you think, Eric?
Yeah, I think it's going to impact a lot of workplaces. I see a question right now. Someone's asking if we didn't extend FFCRA from January to March 31, can we decide now to get back in the game and extend it from April 1 to September 30? I think the answer is definitely yes.
Sure.
Yeah. And mind you, folks, I said, I think it's definitely yes. Everything's going to be a hedge today. We'll try not to say it depends too much. Dave and I have looked at the American Rescue Plan Act. Specifically, we've looked at the emergency paid leave section. I haven't read all 500 or 600 pages. Have you, Dave?
No, and there's over 600. It's either like 628 or 658. It's really long.
Yeah. The Department of Labor hasn't weighed in yet. None of the federal agencies have weighed in yet. So we're giving our best guesses as to what we think would be allowed under the ARP or the ARPA. So everything we say is with a hedge and a caveat and an implied it depends. And again, we're not giving legal advice. So double check this with your outside counsel, right? If Dave and I are your outside counsel, just call us after this. And also, we're waiting just like you are for the Department of Labor to issue some guidance. We didn't get guidance on the first extension, but hopefully we get some guidance this time because have been a lot of questions, but we'll see. Let's see if I can advance slides here. So someone had asked, we got a question, Dave, from before the Zoom. Someone had asked, how is this going to impact federal employers? You want to talk to that for a little bit?
Well, there's a nuance. Someone actually during this presentation asked about, does it apply to public employers? And the answer is, it's not real clear. Hopefully we will get some clarification from the Department of Labor, but if you see the language in the statute, it is actually a little different than the FFCRA statutory language. This one specifically talks about that the credit shall not be allowed to the government of the US or any agency. So probably federal employers will not get a tax credit. I'm not sure how you even would have a tax credit, but possibly, and hopefully we get some clarification on this. I know that there's some discussion that there's a possibility that other public employers might be able to take a tax credit against Medicare taxes. So that could open the door for some public employers to do it. But in general, there's no mandate. But what we do know is that private employers will have access to the tax credit, and some private or some nonprofits. When I say some nonprofits, is because I'm not a tax attorney. I don't think Eric is going to opine on this either, but you can see the language there. It doesn't talk about 501c3s, which is what a lot of people are. It talks about that, basically you can get tax credit if you're 501c1 and exempt from tax under 501a. So some nonprofits probably fall within there. And those people now, they never got it under the FFCRA. Now they possibly can get some tax relief.
Yeah, Dave, I know just enough about tax to call one of my partners. If I had stayed at a Holiday Inn Express last night, maybe I'd know a little bit more about tax, but not my bailiwick at all.
Yeah, me neither. And I'm not a CPA. I always tell my clients, you need to check with your CPAs about this, but this is brand new for them too. It just came out.
Yeah. So I just flashed a slide. We talked about this already. This runs from April 1 to September 30. Now, a bunch of the questions I got in advance is, hey, Eric, what if we only wanted to run this until July 4th? Can we do that? I think the answer is yes, because it's voluntary. What do you think, Dave?
I agree. I think someone could just give 2 weeks for spring break or whatever. It's completely voluntary. The world of where you can get the tax credits from only goes through the end of September. So if you're thinking you're going to be able to dip into October, unless there's some extension from some other legislation, that's not going to happen. This will expire at the end of September. But no, there's a lot of things you can do. But if you want to get the tax credits, then you need to work within the rules that are set out here. And this slide that's on the screen right now is one of the key ones. You can't just give, the paid leave to high seniority individuals or highly compensated employees. If you're going to do that, then you're not going to get the tax credits at all. If you're going to do it, you need to give it pretty much to any employees.
What about guys with mustaches and soul patches?
Only if they shave in funny designs.
Okay, cool. Yeah, and I hope that most of the people who are listening here, who are dialed in today, aren't going to be discriminating against the lower level employees just to give it to the folks in the C-suite. But this is part of the statute. Another.
We'll get to your question, Laura.
There is a question. Can employers offer employees EPSL and not EFMLA? I think the answer is yes. What do you think?
I agree. I think so too. I think because there's no mandate, there's a lot of leeway for what employers want to do. I think if an employer only wants to give 2 weeks, and it's real simple to do because you just tag it under emergency paid sick leave.
I'll get that back in a second. I got to let people in from the waiting room. Sorry, keep going.
Yeah, I think there's a lot of leeway on employers. If you don't want to give full 12 weeks, you don't have to. But if you're going to do that, if you're going to give them anything less than what they probably are thinking, what they're hearing on CNN, if you're going to give them anything less than the full 2 weeks for EPSL or the full $12,000 for EFMLA, then you probably need to let them know from the get-go, because you don't want claims of discrimination coming in later on where they say, well, you know what, 3 Black employees got it at the beginning and then they chopped it off for the rest of us. You don't want, the way to avoid that is if you're not going to give the full amount of leave that's envisioned here, just let your employees know from the get-go. But you do have the ability to craft it however you think works best for your workplace.
Another question for you, Dave. What about the 10-day bank of EPSL?
Okay, and that's complicated right now for the next like 2 weeks, because this under ARPA only kicks in on April 1st. So if you have an employee that exhausted their 10 days of FFCRA paid leave, then they're done. However, under Trump's extension, we have you're able to extend that out till March 31st. What that means is that if someone did not already use their EPSL leave, then they can use it up through the end of March and get the tax credit. But the issue is, well, what happens if someone used it all up? Do they get a new bank of leave? That starts on April 1st. So right. If someone already used up 10 days, do you agree with that, Eric?
I think if I have 0 days of EPSL available on March 31st, and my employer wants to continue this, I've got 10 new days on April 1. If I have 10 days that I've never used on March 31st, I think come April 1, I've got 10 days only.
Yep. Yeah, under no circumstances should employees get 20 days.
No, you never get more than 10. That's how I view it too.
For the EPSL. Now the EFMLA is different.
Correct. And that's a good point. And there's basically complete overlap at this point. So your first 10 days of any form of leave would be EPSL leave that would run concurrently with the EFMLA. Do you agree with me?
Yes, and it could be either at 100% of the pay or 2/3, depending on what the reason is for the leave.
Correct. And then there's God, it's been so long, Dave. Then there's you can top people off and take something out of their account, and it's been so long since I've looked at that issue. But yeah, suffice it to say, there is the full pay version up to $511 per day for if you yourself have coronavirus, you are going to a doctor to get checked out for symptoms related to coronavirus, or if you're subject to a state, local isolation order. I don't think anyone is anymore, fortunately. And then everything else is the 2/3, including. Well, wait a minute. Where does the vaccinations fall? Do you remember that one?
Yeah, that's basically a new reason for leave under either the EPSL or the EFMLA. I think the issue is going to come up on day 11. If someone triggers any of this leave and they're out of work for at least 11 work days, at that point, the only available leave is EFMLA, which is capped at the $200 a day, the 2/3 of their pay. Do you agree with that, Eric?
It's 2/3, yes, for the EFMLA. Correct.
Yeah. So if someone's out 14 days, 21 days, they should not be getting 100% of their pay under this tax leave under ARPA. Now, it's different if they're going to top it off with their PTO or something like that, but the tax credit will only be applied up to the 2/3 of their pay once you get into the EFMLA.
Right. Hey, someone raises a good point. Maybe I misspoke. So someone said, why would EPSL and EFMLA run concurrently if the new maximum tax credit is $12,000? You have a good answer to that?
Hopefully the Department of Labor guides us on that, but I don't see any way that anyone's ever going to get a full $12,000 with just the EPSL. I think the only way they're going to get there is using the EFMLA.
Well, I guess you could use your first 2 weeks of EPSL could be $200, right, for each week. So that's $500, $1,000. Then you take which would be unpaid EFMLA for those 2 weeks. The first 2 weeks would be unpaid, and then your last 10 weeks would be.
I don't think you need to do that anymore.
I think at $1,000 a week, there's your $12,000.
I don't think there's any unpaid leave at this point for the first 2 weeks. I think it's all paid now.
Well, my point is the EFML, while it runs concurrently with the paid sick leave, the EFML portion would be unpaid. You get paid under the PSL. That's 2 weeks at $1,000 a week, right? $200 a day. So there's $2,000. And then the final 10 weeks after your PSL runs out is all EFMLA at $1,000 a week for 10 weeks. $10,000 plus $2,000 is $12,000. How's that sound?
I think that's correct under the old FFCRA. I think under ARPA, I think the cap for the EFMLA, which used to be 10,000 on top of it, is now expanded to 12,000. Hopefully we get some clarification from the Department of Labor to clarify this. But I think this is one tweak that's a little bit different from the straight up FFCRA. But yeah, there's going to be a lot of things that lawyers don't know the answer to immediately, and it's just our best guesses.
Yeah, come on, Marty Walsh. You watching this? Are you logged in? Come on, let's go. Let's get some guidance. All right, let's move. I stopped with the slides, but let me advance some slides. We talked a little bit about immunization. I wanted to bring up something. You made a great point, and I'm going to segue a little bit and go out of order. There's some new CDC guidance about testing asymptomatic workers in the workplace. Do you want to talk a little bit about that and how that could interplay with FFCRA?
Yeah. You want to jump on up to that slide?
Sure.
I think it's towards the end of the packet.
All right.
Generally, there's and it's just it's not a mandate, but it just came out the day before. There it is. The day before yesterday. So the CDC, you can see that they're talking about testing asymptomatic people that are not, exposed to someone that they know has COVID. This is the first time that we've seen something where it's been brought in this way. And the way they're talking about this is that they say employers should be considering doing something called screen testing or screening testing. And this is an option where you can either, can you advance it to the next slide? It talks about what kind of workplaces it would be appropriate for. And it says, like restaurants or salons, basically places where you have close contact with the public. Also, if you're in a workplace where physical distancing just is very, very difficult, like a food processing or manufacturing facility, or, and this is the real catch-all that will cover pretty much anyone, if you're a critical infrastructure sector. So basically, if you never shut down, then that's going to be a critical infrastructure sector. And also workplaces with high proportion of immunocompromised or older workers. Those are the kind of situations where this is going to be applicable. And they say that, one way to do it, you don't have to do it at all, but one option is to do it where you have basically all workers before they come in the workplace, or you just target test if you're starting to bring people back to the workplace. They've been on work from home for a while and they're just now returning from a long absence outside the workplace, or if they were on maternity leave or any kind of medical leave or furlough and you bring them back, that would be a good way to do it. And you get the thing at the bottom in green is the big eye opener. CDC recommends conducting screening testing at least weekly. That is going to be very difficult, I think, for a lot of employers. However, one option that I at least think could be possible, and I'm not saying that this is going to work for every workplace, is if you scroll back now, Eric, to some of those other slides where we're talking about the reasons for the leave. And basically, if an employee wants to go get tested for COVID, that has always triggered FFCRA protection. But now an employer can trigger that themselves. Not that slide. That slide there was the original 6 reasons for COVID. But you could see there, like reason number 2 and reason number 3 required either the seeking a medical diagnosis or being advised by a healthcare provider to self-quarantine. The employer couldn't trigger those 2 on their own. Now they can. Now I don't know if you can find that slide. It's not that one. But there's one that basically the employer can send you for a COVID test, and that would trigger the tax credit, which I think should allow employers, if they wanted to do that screening testing, to possibly get the tax credit for it. Now, it's unknown what happens if insurance doesn't cover that. I don't think we have guidance. This just came out a couple of days ago, so I don't think that the relevant parties have issued any kind of guidance letting us know whether or not there's going to be insurance coverage for that. And this kind of gets into the OSHA and the funding for investigations. I don't know if you're ready to jump into that yet, or you still want to talk more?
I just had that slide up. We'll get there in a bit. So let's close the loop here. We want to have testing for asymptomatic workers in our workplace. We want to be incredibly risk averse. First question. First issue, I think that's pretty clear. There's nothing under FFCRA, the American Rescue Plan, that says that the tests themselves, the actual physical test that you administer, is paid for by the government, right? That may be on the company unless insurance is going to pick that up, correct?
I agree with what you just said.
And again, neither Dave nor I have read all 600 plus pages, but I haven't heard anything about that being covered by the government. So then the question becomes, all right, you're telling your employees you need to get tested by us. Theoretically, you could pay them under the FFCRA for the time they spend queued up to get tested, because I know this is where Dave and I differ. I think under the Fair Labor Standards Act, that is non-compensable time, the time that you spend temperature checking someone, or in this case, testing them for COVID. And I think, Dave, you disagree. You think the Fair Labor Standards Act would cover that.
I don't necessarily disagree. I do think that it's a risky area for employers to gamble, and a lot of employers are going to have to make gambling decisions, how much risk they're willing to take. But at the end of the day, it may be found to be compensable, and one court may rule differently from another court. But it's an area that is unknown at this point across the country.
Yeah, there's a case right now actually against Amazon, where I got a hit this morning on Law 360. Shout out to Law 360. There was a decision that employees who had alleged that the time screening to get in, I think temperature check screening, was compensable time under state law, I think they alleged. So your mileage may vary depending on the state, but the judge let that claim get past a motion to dismiss. So the idea, folks, sorry, I should reset here, is that under the Fair Labor Standards Act, time spent queuing up in a security line, for example, to get into work is probably not compensatory time under the Supreme Court's decision a few years ago in integrity staffing, because it's not indispensable and integral to what these employees do on a day-to-day. But here we're in a little bit of a different situation. Is testing people for whether to see if they have a fever or whether they have COVID, is that integral and indispensable to what these employees do on a day-to-day? I think that's the issue. Maybe slightly nuanced. I don't know that it is, my personal opinion. But that's what's going to be litigated now. And that's if it is integral and indispensable, that time spent queuing, if you're not exempt, is compensable time. If you're exempt, you're getting paid anyway. But if you're non-exempt, you'd get paid for that time you're spent waiting to get your temperature checked.
Eric, would you agree that if an employer is completely risk adverse, what it would do would be to compensate individuals for that time?
Yeah, I mean, if you're completely risk averse, sure.
There will be litigation on this.
Yeah, go get a dog to keep your, to keep yourself warm and cozy, right? It's okay to have a little risk aggression. Am I recording this? Oh, right. If you're before you get risk aggressive or risk averse, consult outside counsel. Remember, disclaimer, we're not telling you what to do. This is a free Zoom. We're lawyers. We're not your lawyers. We're not creating any privilege.
And also, would you agree that workplaces differ, such as if you have a mom and pop place with maybe 15 employees as opposed to Disney World, where there's massive lines and long waits?
I agree. I agree. It is very fact specific, and that's what even Amazon conceded that in its papers, that the analysis is fact specific, and I think that's by and large why the motion to dismiss was denied in that case. And the parties are going to take discovery to see what the employees do on a day-to-day and whether getting temperature checked is integral and indispensable to what they do. So,
and there are other issues, like for instance, does your local mayor or county or city or governor require these tests before the workplace, or is the employer requiring these tests? There are going to be fact-specific issues that may be very different from whatever happens with that Amazon case.
Well, this is a good natural segue into OSHA, Dave. Is this our first OSHA slide? I guess this is our oh no, this is our first OSHA slide. So I'll set it up, and then Dave, you hit it out of the park. So okay. Recently, OSHA announced that it was going to get pretty aggressive on COVID-19 workplace inspections. And as you can see here from the slide, and Dave will talk more about it, there's some money being sent over to OSHA to accomplish this. They're going to do it remotely, they're going to do it in person. But if you're in a state like Texas, Mississippi, or any other state where, right or wrong, I have no opinion about this, at least nothing that I'm going to share today, where the government is going to relax all restrictions on masking and things like that, don't forget about the federal rules, and namely OSHA. And now, Dave, I'm going to turn it over to you.
Yeah, maybe let's advance it one slide and we'll go into the next couple ones. In general, OSHA applies to almost every private employer across America. And the part that we're talking about is what's called the general duty clause. Employers have a duty to keep a workplace free from hazards. And the question is COVID in the workplace a hazard? And I think it's going to be pretty clear that it is. So if you advance to the next slide, what has been coming out recently is, I think the date was January 29th. Yeah. So this is not the standard yet. This is not a mandate. However, this is probably what it's going to look like. That's my best guess. It's sitting in the White House right now, getting tweaked. But in general, on January 29th, they issued a multi-page document. If you scroll to the next one, these are the kind of things that we're probably going to be seeing within the next couple of weeks in the standard. It's the emergency standard. And in there, you'll see that they're talking about that employers probably are going to be asked, and this is a should at this point, but it's probably going to be mandatory. But this is important because this is, if you're sued later on, and if you're asked in deposition, what steps did you take? You said, well, we did everything the CDC told us to do, or we did everything that OSHA told us to do. This is what OSHA is recommending. So they're saying, you should be having a workplace coordinator responsible for COVID issues. You should be installing barriers when you can't physically distance. You should be having some kind of face coverings. You should be improving your ventilation. The CDC talked about ventilation months ago. And some of that stuff's free. You can open a window and put a box fan in there for free, and that will drastically improve ventilation. Also, if you switch to the next slide, and there's a whole bunch, I'm just going to hit some of the high ones here. Working from home, that's the big one. That's a real easy way to prevent the spread of COVID in the workplace. The more people you possibly can have working from home, probably the better off you are to contain COVID spread. Also, you should be instructing workers that are potentially infected to stay at home. And I still, Eric, I don't know if your phone rings like this, but my phone is still ringing, and employers are saying, hey, you know what, Bob, had COVID symptoms, so we sent him for a test. And I'm like, okay, And they're like, well, he's really important, so he's working right now. This blows my mind. If someone is testing for COVID because they have COVID symptoms, they should not be in your workplace. They should be home. What happens if they test positive? Then you've just infected a whole bunch of other people. So if you're going to tell someone to stay home, those absences should not be punitive. That means if you have 5 absences and then you're written up or you're fired, that has to go by the wayside, just like under the ADA. If someone is taking absences due to an ADA reason or FMLA reason, you can't discipline them for those absences. That's
what the FFCRA is for, voluntarily. I mean, and it's free.
Yes.
Effectively, if you have
Yes.
500 employees, let the person stay home. Now, okay, there are certain people who you're going to deem indispensable to the workplace, and I thought you were going to go in a different direction, Dave, because I'm getting a bunch of calls, and I'll bet lawyers on this Zoom chat are getting the same calls. Look, government's relaxing the rules. When can we bring people back to the workplace? We want to bring them back. Remote work is over. Come on, let's bring them back. But you still do have a few weapons in your arsenal to allow people to stay home, to be safe, to avoid issues with OSHA, and it doesn't cost you anything, at least in terms of wages or salary or paid sick leave or anything like that. It might cost productivity, but
I'm seeing a lot of, and I call them dinosaur managers, that have a butts in the seat mentality. And they're like, listen, we need people back at work. Well, they may want them back at work, but we've seen for 12 months now, plenty of people are able to work effectively from home. Now, some aren't, and I understand that, but there are a lot of people that we never thought, or at least some of these managers never thought could possibly do their job from home. And they've been doing it. They've been excelling at it. So I think the work from home really needs to be, you shouldn't be rushing them back to work, especially if they've got certain medical conditions or if they're exposed to COVID. Those kind of people absolutely should be talking about reasonable accommodations, letting them to continue to work from home. If you want to advance a couple more slides here.
Yeah, and there's a point made in the comments, and Marta Griffith noted this, that essential employees in critical infrastructure, if asymptomatic, can continue to work, and that's true.
Yes.
If you're vaccinated and you're asymptomatic, you can continue to work under the CDC guidance, right? If you've had COVID in the last, 3 months, and you're asymptomatic and you've had close contact, you can continue to work.
As long as it's been 2 weeks since your second COVID shot.
Yeah, exactly. But I think this is also slightly different because the scenario you were giving is, I think someone was dealing with symptoms of COVID. They thought enough about it to go to a doctor to get tested. That's not what you want to bring back to the world.
That's right. Now, the next slide is really important because it gets into the retaliation aspect of it, and OSHA is going to nail you. It's also going to be an NLRA violation, most likely, too. But if you see number 13 and 12, employees are allowed to talk about terms and conditions of employment. So if they're afraid to come to work, if they don't think that you have enough PPE, face masks, things like that, and they talk about it, you can see in this OSHA document, they're very clear that you should not be discriminating against employees for doing that, including making comments, raising concerns of terms and conditions of employment to the public, such as through social media. I've seen policies that say, if you've got an issue, come to your manager, only your manager. Well, that's almost certainly going to violate the NLRA also, but you can see that it's going to probably be an OSHA issue here as well.
State law as well. I don't know.
Yeah.
Florida's pretty permissive, I think. I'm not licensed to practice there, but where I am licensed to practice, for example, it's a tale of two different, well, one's a Commonwealth and one's a state. So in Pennsylvania, there is technically a whistleblower statute, but it's really limited to public employers and those who receive public funds. Now, if you fire someone for complaining about workplace conditions, it might violate the at-will exception. There's an exception, public policy exception to the at-will doctrine in Pennsylvania. And there's already been a case that survived a motion to dismiss where the court said, employee complains about working conditions in a health setting, for example, and they're fired or they're disciplined. They're all fired. There may be a cause of action there. In New Jersey, which is, I joked about this before, California is the New Jersey of the West. I mean, New Jersey has taken the crown, folks. Very robust whistleblower statute, the Conscientious Employee Protection Act. if I complain about working conditions or I complain about what I perceive to be a violation of the law, let's say related to COVID-19, right? And I'm fired for that. Maybe I'm wrong, but I have a reasonable belief, I still have a claim, if I was fired for that reason. So to Dave's point, you're going to have federal issues under OSHA. You might have NLRA issues, and you might have state law issues. You could have local issues too.
And Eric and I are both lawyers, so we're heavy on the legal part. But as a practical matter, you're going to have a PR nightmare if your NBC affiliate or CNN rolls up in your parking lot and starts running a news thing talking about how you fired this person because they're concerned about not having enough PPE. And we've seen a lot of news coverage about that kind of stuff.
Very true. Very true. I have a question here because we were talking about vaccinations and talking about when people can come back to work and if they're asymptomatic, things like that. Laura's asking, what about a small workplace where every employee is fully vaccinated? Do you still social
great
distancing?
question. Next slide.
Desks,
Next slide.
Oh, perfect. Laura, thank you. We're going to hire you. For our next thing. Thanks, Laura.
So in this document from OSHA, there's, and this may change in 3 months or 6 months, but right now, what they're saying is there's frankly not enough people that are vaccinated. It's only like 10% of the public that's vaccinated. So at this point, yeah, even if every single person in your workplace is vaccinated, they're still saying you should be wearing face masks if you can't social distance. You should be social distancing if you can't. That is what the current information from OSHA is. And at this point, it's not a mandate, but we're fixing to get a mandate within less than 2 weeks probably, and I bet you it's going to look a lot like this document.
Yeah. Yes. So, but there has been, we have seen separate CDC guidance that says that if you're vaccinated and you're in someone else's home and everyone else is vaccinated, you can take your masks off. You don't have to socially distance. I mean, to the point where if everyone's vaccinated but one person who is low risk, basically everyone can take their masks off. So I could take a deposition live. I don't intend to take any live depositions anytime soon, but if everyone in the room was, let's say, vaccinated but for the deponent, we could all sit there in the same room without social distancing and carry on a pretty normal deposition.
Let me raise an issue because of number 15.
Go ahead.
All of these vaccines are not 100% effective. Even the very effective ones, the first two that came out are what, 90, 95%? And then the most recent one is, I think, 74, 75%. So there's a certain percentage of people, even if they're vaccinated, that are going to be able to get COVID and spread it. And
No
right
different
now,
than the flu. Right.
Yeah, and it's still such a new thing that we don't know for sure. I don't think that the science is there as to whether or not someone who has gotten the vaccine still can't spread it. So that's part of the reason why these are and things may change in the next couple months and this may disappear. But that's where it is right now.
Oh, and let me just qualify for anyone who's seeing this on YouTube, because I'm going to post this to YouTube when it's done. I'm not saying that COVID is the same as the flu. Okay. I'm just saying that the COVID shot is not 100% and a flu shot is not 100%. There, I've clarified. Thank you. All right. What else did you want to talk about today, David? Because I have other questions.
I think we can blow through the next several slides in less than a minute.
Okay.
I just want to give you some examples. There are only a handful of places around the country that have like their own state OSHAs, like Oregon, Michigan, California. But these are some examples of when the OSHA standard comes out, what you're likely to see. And you can see that this one here involved 2 machine operators who basically were 2 feet next to each other, and they didn't have to wear protective masks, and then they got COVID. So you can see at the end of the day, I think someone died here in this one, but they only got nailed for $15,000. But that's the type of thing that's probably likely to come out under the Biden OSHA. And if you look at the next couple slides, these are all from state OSHAs. But this is what I would expect to come out after the ETS is issued. And you'll see, $5,000 for not having physical barriers or not screening employees. Another $5,000 for not having face coverings. $8,100 for not doing an exposure analysis or failing to notify employees properly. $2,000 for not doing considering a face shield. And you can see that the CMPs, the civil monetary penalties, the maximums, the first time you get nailed by OSHA, it's about $13,000. but it's 10 times that if you have a repeat. So if you've already gotten nailed by OSHA in the last couple of years, and if they show up at your workplace again, and if it's the same kind of violation, that's going to be a repeat. Can shut down a lot of businesses. So this is not something to be taken lightly. And frankly, if they come by the first time and you get nailed, they're going to come back again in the next couple of years. And if they find something, which they tend to find, you can be out of business with $130,000 civil monetary penalty.
All right. Hey, Ray, can I ask you to turn off your video if you don't mind? Thank you. Someone asked, I just saw this flash up. This is a softball, but a great question, which I assume other people have. Can we require employees to provide proof of their vaccinations? Absolutely. The EOC has said you can do that.
Yeah, you don't need page after page of documents. Everyone's posting stuff on social media. It's like a little thing, and it just shows like the date and all that. That's usually going to be adequate.
Yeah, and what I've done, I've gone out and gotten some vaccinations. I've got my card and I've taken a picture and just put it on my phone. I know at some point I'll lose that card. So, let's see. There were some other questions that people had submitted in advance, Dave, with respect to FFCRA. I think
sure. Let's go through them.
A hot topic here today. So we talked about having to reload EPSL balances. Here's a question that I don't know that we answered yet. We said you get a new 10-day bank of paid sick leave, but under the American Rescue Plan Act, as it deals with all that FFCRA voluntary stuff, do employees get a new 12-week bank of EFMLA? What do you think?
I think beginning April 1st they do.
Okay.
Which means that sure. if someone's already used up 12 weeks, I think it is like getting a new $12,000 of basically the second quarter of 2021. That's and I don't think it's clear. I think that's my best guess on it. Hopefully the Department of Labor will clarify that, but my best guess at this point is yes, I think they do get a new bucket of, and this is voluntary. You don't have to give it to them if you don't want to, but I think you can get the tax credit if you choose to do that.
And someone raised the magic question, right? If there's a reload of EFMLA, right, and people use it going forward, does that count against classic FMLA?
What do you think about that, Eric?
Well, they're all under this, it's all technically part of the FMLA, right? Because the FMLA was amended to add these additional reasons. Well, just really to add for taking care of a child who's home from daycare because daycare is closed due to COVID or school due to COVID. But now we have all of these other reasons, which Congress and President Biden have now said are part of EFMLA, right?
Yeah. I think you do it the same way that you've been doing it for the last year. I think most people on this call should have been treating EFMLA just like FMLA, and it counts against classic FMLA. That's what you probably did in 2020, and I think that nothing really has changed in 2021 from that perspective. I think it does run, essentially it burns down your FMLA leave.
And there may be situations where there is a natural overlap now, where we really didn't necessarily have it before back in 2020. So for example, if God forbid, a loved one gets COVID, really bad COVID, and I need to stay home to take care of them, that qualifies under EFMLA for sure.
That's a great point.
And that qualifies under FMLA.
Yeah, up until April 1st, only reason number 5 on the poster, the child care due to closure of school or daycare facility, is the only one that qualified for EFMLA. Now everything does, including vaccinations. But all of the bank, everything on that poster now qualifies for EFMLA plus the vaccinations.
Right. So I had another question, and I love getting these questions, Dave. Every once in a while, I'm not going to out this person because I get enough of these, and it's not just one person. This person probably speaks for other people, right? But I get the cynical HR question, right? And here's what I mean by the cynical HR question. It's this.
abused.
Okay, so now the ARP allows people to get EFMLA paid leave for getting a vaccination. Great. I would think it would only take an hour or two to go out and get your vaccination and come back to work. What if someone takes 8 hours to get their vaccination, come back to work? Do we have to pay them for all 8 hours? What do you think? Can you as the employer limit leave to 2 hours?
Yeah, I think the only thing the employer cannot do is exclude people based on seniority or highly compensated. That's the part that's in the statute. It says that you can't do that. I think other than that, it's voluntary. You can say, we're not giving everyone 12 weeks. We're, $12,000. We're only going to do it for 2 weeks. I think there's a lot of leeway on employers. And yes, I think they could say, if you've got a COVID shot coming up, we'll give you 2 hours of leave, or we'll give you half a day. Yes, I think employers do have the flexibility to do that. At the end of the day, it's a tax credit. So some employers will say, it's free money, I'll give them whatever they need. Some other employers will say, no, we're getting too much abuse here, we're going to cap it at whatever we want. And I think they can do that.
But if you're going to deviate from what is the ceiling, basically, and you're going to set the bar lower, you'd better commit that to writing.
And if you're going to cap it, you better cap it for everyone. You better not let the 3 Black people get one amount of leave and all the other white people or Hispanic people or whatever a different amount of leave, or else you're opening yourself up for discrimination there. And I'm talking about any protected class. I just randomly picked some, but any protected class, if you're treating some different from others, you can have an adverse impact, claim.
Yeah, 100%. And make sure
Despair.
Managers understand that this isn't a free for all. That if you're going to create rules, right? These are documented rules, policies that are enforced to the letter. That no one exercises their own discretion to say, you know what, this person, we don't want to give them the whole 12 weeks of leave. Let's give them 9 weeks of leave just because some manager decides otherwise. So update your policies. I know a couple of lawyers who could probably do that, just saying. And then update your leave request forms too, because you've got 2 new leave reasons. And
that just answered the last chat question that popped up too.
And also, so what is your proof? What is the proof that you'd be asking for that someone is, going to get vaccinated? And remember, folks, we're keeping documentation not for, our own purposes because we like to keep documentation and fill up our servers, or people who have, filing cabinets. We're doing this for the Internal Revenue Service, right? So that's why the documentation that employers had to keep in 2020 wasn't that robust.
It's all for the tax credit. That's all, just to justify that you did it properly. I
mean, really, all we needed was like the name of your doctor and the date of the appointment. And you certifying that you're going to get tested. That's it. So I think if someone certifies, look, I'm going to get my COVID shot this afternoon, or just certifies, look, I'm staying home the following day after my second COVID shot because I've got the chills or whatever the side effects are. They don't have to go to the doctor. That's enough. That's
right.
And I'm guessing that's what the Department of Labor is going to say. Guessing.
I think you're right.
Yeah. So we've got about 10 minutes left. We've covered a lot.
Were there some more of those questions that you got in advance?
Well, I see a lot of questions that are popping up here. Are there any questions that you had that we had discussed in advance that you want to address? Otherwise, I'm going to go to the chat, which is...
Yeah, I think let's go to the chat. I think it overlaps. There's some questions about, do you get new buckets of leave and all that kind of stuff. I think we've addressed it, but I'm more than happy to answer anything in the chat.
I'm going to answer the easiest question. Will this presentation be recorded and sent to us? It's being recorded. I did remember to hit record. So I'm posting down in the chat window below all of the links to Dave and I, including a link to the Employer Handbook YouTube channel, which is where this recording is going to be when I finish uploading it. And folks, I'm going to put little chapters in there so you can fast forward and know where you want to go. I'm going to do it right this time. So yeah, it'll be up on YouTube. That was the easiest question. I'm going to ask you folks a question while I'm getting through the other questions, and you can post these in the chat. What are some of the topics you want to see us address in the future? I saw Cobra earlier. You don't have to say that. I know Cobra. Other things I was thinking about, how about data privacy and what to do with all that vaccination information that comes in? Do you want to see something on privacy and COVID-19? But if there are other topics that you want to see us address specifically, put them down in the chat. All right, let's see other questions that we've got.
Someone was asking about a poster, Eric. What do you think about that? Do you think one's coming?
A new poster?
Yeah. If so, where would it be coming from?
Yeah, I don't know. I don't think so.
I don't either.
I think the poster went up before because it was
There's a mandate.
And employees need to know what their rights were.
Yeah.
We're going to see a new poster. Sorry.
I don't either.
That'd be nice. Let's see what other questions do we have. What about new hires 2021 January to March for EPSL and EFMLA? What is that? Let's see. I'm trying to if we have a new hire, can those people get in the game for April to September? I guess that's the question. What do you think? I don't see any reason why new hires are disqualified, although, oh, I'm drawing a blank. EPSL, you can go right away, but there was a 30-day wait.
30-day wait
for EFMLA.
That's correct. I don't know off the top of my head if that applies beginning April 1st or not, but yeah, if someone just got hired 2 weeks ago, they're gonna, I mean, if the employer voluntarily wants to open up, the tax credits and use EPSL, I think they can do that either now or starting April 1st or both.
Right, but for EFMLA, there is that 30-day wait if you want to get the tax credits, right? If you want to be more generous and not get any tax credits, you could start people sooner.
Sure.
Also, and this goes, it shouldn't go without saying. I should say it, and I'm saying it at 12:54, and we've got 6 minutes left. I should have said it more early on. Don't forget about state laws, folks. I mean, we're focused here on federal law, but if you're in New York, for example, New York City, there's all sorts of paid leave available. I'm not a New York lawyer, but I know just enough to call one of my partners who I see on the Zoom today. I'd call her. If you're in New Jersey, if you're in California, there are certain, I don't want to say progressive or non-progressive, but there are certain states and localities that have more generous leave rights than are available under the FFCRA. So don't forget about that. Just because you're complying with the FFCRA doesn't mean you're necessarily complying with state and local law. Oh, let's see what other questions. Oh, here's a question. What about someone on a rolling 12-month FMLA date and they have already used it and the reset date isn't until late summer? Can they use I guess the question is, can they use EFML starting April 1? I think we've concluded no, right?
I don't know. I think maybe they can, because think about all the employers that were never covered by the FMLA. The employees still get EFML. Yeah. I think in that situation, they would still have the full EFML if the employer wanted to. There's no mandate. I don't think they have to. But I think if the employer wanted to, they could give them the EFML for that situation. If it's one of the COVID specific reasons, if it's one of those reasons that's covered on the poster, or for vaccinations or vaccination side effects.
Yeah, well, and certainly people could use paid sick leave right away, right? That because that's different. All right. Someone asked, is there a new poster for ARPA? That'd be a really long poster. No, not that I'm yet.
No, I think there's gonna be various. I mean, maybe IRS will have one poster. I don't know. There's so many different things that are bundled into ARPA. I don't see a poster coming out for any of this stuff. Hopefully, I'm wrong, but I just don't see it because it's not a mandate.
Okay. I took down the slides. We're now big and focused. Let's see. We got a couple minutes left. What other questions? Oh, here's a good question. We haven't talked about EEOC much today. Where does EEOC stand on testing asymptomatic employees? I don't think they've said anything one way or the other. But I will say this, David. I read an interview with Chair Burrows, who was asked about COVID-19 issues, and I hope I'm not misquoting her, but basically she said, we're going to follow the science. So if that's any indication, I mean, that's a very broad statement. And I don't think the EEOC would stand in the way of testing asymptomatic employees. I mean, heck, you can temperature check people because of COVID-19. I don't think the EEOC would have any issue with testing asymptomatic employees.
Yeah, it'd be real nice for the EEOC to give us some guidance, because they have given us, they've updated 2 pieces of guidance during the pandemic. And in there, one of the things that specifically talked about was if an employer had a reasonable belief of, that they could test someone, they can do the temperature before they come in the workplace, and they could single them out. They don't have to just do everyone. And the reason is if they have an objective reason that they may have COVID. And what is that? If they have any of the COVID symptoms. So there's something there. Whereas this is pretty much anyone. I don't think that this would necessarily trigger that. So it'd be really nice to have some guidance on that from the EEOC.
Watching the EEOC? Come on, give us some guidance. At some point in the future, I nearly promise, folks, almost promise, can almost guarantee we'll have some folks from the EEOC on here with me, and we'll talk about some of these issues in greater detail. It is almost the top of the hour, 2 minutes before 1, 12:58 on your computer screens. So we should probably wrap it up. Dave, want to plug anything? You want to tell everyone how to reach out to you and get in touch and connect on LinkedIn and
Sure.
Good Florida Lawyer, all that kind of stuff?
It's a lot easier to just follow me on LinkedIn. That's I'm there every day. I try and limit the people that I am actually connected to, because it messes up the algorithm if I'm connected with too many people out of Florida, because I only represent Florida businesses. But you can always follow me. But LinkedIn is probably the best way. Just type my name in there, and there's a couple guys out in Eastern Europe. But besides that, I'm pretty easy to find, and I regularly post, just like Eric. We're both posting pretty much every day.
Yeah, folks, Dave is a machine posting on LinkedIn. He is great follow, great attorney, and I'm so honored and pleased to have him with us today. And thank all of you for attending. We love having you. We love doing this. I think we're going to have another one next week. I think next week's is going to be about privacy issues relating to COVID-19. That's the tentative plan, but I will shore that up. If there are other, like I said, if there are other topics you want to see us address, you can drop it in the chat. You can email me. You can message me on LinkedIn. Here's all the good stuff again to connect with us. Thanks, everyone. I remembered to hit the record button today, so I am ahead of the game. Everyone, thank you. Stay safe. Have a great weekend, and we'll see you hopefully next week.
Thanks for inviting me, Eric.
Bye.
Bye-bye.